The number you have reached, 911, has been changed to a non-published number.
Okay, criminal law. This year, for those of you that have bothered to look at what my breakdown of the entire years of cases have seen, it went from last year, there were 37 pages once I broke them all down. This year it was 67. So, there's a lot more stuff. Now, I have different hypotheses for this, part of which being the 8 new judges. And when you get new judges on the Court of Appeals, the judge who's been there 10 or 12 years just writes, you lose, C. Jones against Commonwealth. Well, a new judge goes, you lose, and here's the 17 reasons that Jones against Commonwealth says you lose, right? And they write it out in like 8 pages. I think they'll get over that after a little bit. I think there's also some philosophical differences that are playing out now in the Court of Appeals, and so judges on whatever side of these philosophical differences are feeling like they have to justify themselves in writing it out, right? But be that as it may, there also seem to be more issues that they were interested in this year, and we'll get through all those. But let's get actually moving, get through them. Okay, we start with the Constitution. First, we got the Fourth Amendment, the 15-day rule for turning in search warrant information, what the inventory is, right? Has to be turned in within 15 days. Well, as anybody who's done anything with electronics that are being broken down and analyzed, phones in particular, that never happens, right? Never, ever happens. And in the Walker case, they raised that issue. They're like, look, this guy can turn in. Can somebody kind of kill the lights a little bit so that people can see the thing? Somebody, Walker said, look, it got turned in post 15 days, and the Court of Appeals says, well, yeah, they're not vampires, Corey. The Court of Appeals says, yeah, it got turned in after the 15 days, but that's a statutory right. There's no remedy in the statute. It's not constitutional, therefore you don't get it suppressed. So even if it comes in after 15, it's good to go. The length that a digital item is held before it is the search warrant served on it, we know over the last couple of years that's been an issue that's come up on a number of things. And his Harvey case, and you're going to see this in a whole bunch of different areas. Let me tell you what this Harvey idiot, well, not idiot, he's evil. This guy was waiting at like bars and things, and as the bars closed down and whatever closed down, if there was some woman or a couple women who were just about blackout drunk, was barely walking home, he would follow them, and after they got home and went to bed and were in a drunken stupor, he'd break in and do evil things, right? He gets caught, and there's a whole bunch of different issues. He must have had a lot of money or, a really good attorney. The attorney raised about 9 million issues. But okay, so first we get here his phone. They wanted some video off his phone, and they had tried, they served several search warrants on his phone that they were holding, and actually some of them were quashed even. So the final one gets through. And why they're serving different search warrants is different types of software are becoming available to look onto the phone. They think they'll be able to find more. And apparently the last time, which was months after, they do find something. I will say that after the 3rd or 4th search warrant was served on the phone, that Harvey and his attorney asked for the phone, well, not asked for it, demanded the phone back as his property, right? But they didn't get it back, obviously. But the length that something's held, there is a reasonableness test, and the factors are significance of the interference with a person's possessory interest, right? That would seem to be weighed pretty heavily in the defendant's favor because it's his property. But I guess if you're in jail and can't even use your phone, maybe that mitigates that some. The duration of the delay, did they ask, 2 weeks, a month in, and have reasons, or is it 6 months, 2 years later? That can cause a problem. Consent or lack thereof, obviously in this case Harvey did not consent. The government's legitimate interest in holding the property and evidence, well, this phone had evidence of the crimes, so they had a legitimate interest in holding it. And did the police diligently pursue their investigation? Well, they diligently pursued it here because they kept issuing search warrant after search warrant after search warrant trying to get into it, and the courts said it was all good. Didn't suppress what was on the phone. Investigative stops, Terry. Now, we all know that you cannot extend a car stop for a dog sniff. We went down that whole de minimis route where initially courts were saying, you held it for a minute, you held it for 5 minutes, that's all okay. And then de minimis started getting longer and longer, 15 minutes, 20, 30, 40. And the Supreme Court of the United States eventually stepped in and said, no, you can't extend the car stop at all. And the only exception that is here in this Miller case in the Fourth Circuit is reasonable suspicion. If the officers have reasonable suspicion of a crime or contraband, they can extend the stop to get a dog there. But circumstances must be such that it eliminates a substantial portion of innocent travelers, right? And they got to be mindful, and of course the court's supposed to be mindful of the officer's experience, and the courts will discount normal nervousness. It's kind of an assumption that if you're pulled over by an officer, you're going to be nervous, right? And they can take into consideration the road that's being traveled on, the time that the traveling was taking place, but they can't take much consideration if the route's being used to transport drugs. I mean, if that was the test, then 23, we could stop everybody on 23, right? Because it's been used plenty of times to transport drugs. And they throw in video trumps the officer's statement. So if the video shows that something happened and the officer says, no, that's not the way it went, well, the video is what you go with. And this one, they basically the officers didn't like the look of this guy. They thought he was acting, and they searched based on the fact that he was nervous. And Fourth Circuit said, yeah, everybody's nervous. That doesn't work. Or they extended it for the dog that was nervous. Curfew, other investigative stops. Curfew. Turner was out after curfew, and this was either during COVID or even one of those places in the cities where they have curfews around HUD housing and that. But he's out after curfew. The officers stop him without any other reason than that. He says, look, there are exceptions to curfew, and they didn't have any reasonable belief that I wasn't under the exceptions. And the court says, look, Court of Appeals says, no, they can stop you if you're out after curfew. Otherwise, how do you enforce curfew, right? They can check to see whether you have a legitimate reason or not. Refusal to cooperate and another person's arrest. Those are not enough to do anything with you, pat down and all that, and detain you. Peters was walking down the street with a buddy of his. The officers were really interested in the buddy, right? They had supposedly had suspicion that he had been trespassing. They stopped him and Peters. They asked them both to flip up their shirts, check to see if they had firearms. Peters' buddy flips up his shirt and goes, go ahead, you can go. Peters won't flip up his shirt, right? And things go forth from there, and whether or not there was grounds to arrest the other guy, and the fact that he wouldn't cooperate does not give the officers grounds for a search. So, Fourth Circuit drew a line there. Police errors. Well, let's change the font I use. Okay, doesn't matter. Police errors. Okay, Baskerville against Commonwealth. This is a case where the officers went to the scene for a domestic call, right? They arrive at the scene. There's no domestic going on at the time. They have some evidence that comes from the next door neighbor, who's like the mother or the son, I think, that lives there. They've got the woman who lives at the residence they knock at, comes out. She's not showing any signs of any injury or anything along those lines. But they want to go in the house and search. They want to get in there and see what's going on. And they seem to think that because they've been called to a domestic, they can do a search. And the court says no, and it says your misunderstanding of law doesn't get you out of this, right? Sloppy understanding of the law doesn't get you through this. And then, of course, the Attorney General throws everything they can at it to try to get through this. Independent source doctrine, which didn't work. The only evidence discovered, independent source has to be something that's entirely discovered from a different angle, right? Can't go through the constitutional violation. And the attenuation doctrine, which the unconstitutional conduct is remote, they're not really attached, or there's something that interrupts between the unconstitutional conduct and the service. And again, not here. An unconstitutional statute, we've seen this before, but the Fourth Circuit tells us again that if an officer relies on an unconstitutional statute and thereafter it's found to be unconstitutional, the officer's reliance on that statute is good faith and the evidence will not be suppressed. Exigency, this is Baskerville again, same case. Officers, like I said, Attorney General threw everything they had, including the kitchen sink, trying to get this through. And the court said no. And it says in there, courts really shouldn't should not sanction this in minor offenses. And then they run through various things to check for to see whether the exigency is real. We've seen these lists a million times, but urgency, how long it'll take to get a warrant, do they believe contraband will be destroyed, possibility of danger to the officers or others, possession of the contraband, no, the police are after them, is it a serious or violent offense? And that's what's a little bit different about this. It seems to imply that domestic violence isn't as serious or violent offense as others, right? Which is not a trend we've been on in the past. Are the suspects armed? Is there existence of probable cause? Of course, with exigency, there's going to be existence of probable cause generally. Reason to believe suspects are there, likelihood of escape, and hot pursuit. And the Court of Appeals said no. The right to remain silent. U.S. against Linville, this comes out of the Fourth Circuit. This classic penalty situation, and that is their word for it. The classic penalty situation is when if you don't answer the question, you get thrown in jail, right? Or you don't answer the question, you lose your job. I think it's another way this works. But you don't answer the question, you get thrown in jail. Linville's on probation, right? He signs a little sheet that says, I will answer things truthfully and, I'll answer everything fully and truthfully and all that. And so when he answers things truthfully to the probation officer, he admits to illegal activities, he ends up in front of the judge and gets his sentence revoked. He says, look, I signed this thing saying that I will answer their questions truthfully. And the Court of Appeals, Fourth Circuit said, no, it doesn't work that way. They're government agents too, and if you assert the Fifth Amendment against them, nothing can happen. Which is a really interesting thing to say about probation, because now, if your clients go, I'm not talking to you, the probation officer, right? I still have to do other things, give them their location, and pay a check and all that. But if they just refuse to talk to them, I'm invoking the Fifth. Now obviously this is not a Virginia case, this is a Fourth Circuit case, so it's not directly precedent. It's just informative of where things could be, and it will give y'all something to argue when we come to probation violations. And shockingly, after the Supreme Court shut down our courts for, a year and a half, there were a bunch of speedy trial issues that were raised, a whole number of cases. And I've kind of put the constitutional speedy trial, in which they make very clear is different than the statutory speedy trial, because while Chief Justice can toll statutory speedy trial, he cannot toll the federal Constitution, right? Chief Justice of Virginia can toll statutory, he can't toll the Constitution of the United States. And they go through, and there's a four-part balancing test. And first off, they tell you, whether or not speedy trials run is not tied inextricably to any kind of dates. However, then they go right into the first prong is length of delay. Has it been more than a year? If it hadn't been more than a year, then you can't raise constitutional speedy trial. But after a year, it is presumptively prejudicial. and not by a huge presumption, obviously. It is told if the defense requests a continuance, concurred in a continuance, or was not ready for trial. That's different than statutory, which is told basically if you don't object to any continuance. This, you don't have to object at all to get past the time period, right? As long as you didn't request, concur, and you were ready for trial, you didn't have to object. And the Commonwealth has the burden of proving any time that's told. So that's there. Second part of the balance test is what's the reason for the delay? If it's deliberately improper, merely negligent, or valid and unavoidable. If it's deliberately improper, it has to be something that would meant to hamper the defense, meant to harass the defense, and that is weighed against the government even if the defendant can't show any prejudice, right? If it's merely negligence, and this is scheduling, and I kid you not, they said understaffed prosecutor office, that's there, and or the courts are overcrowded, then it's given less weight. And if it's a valid and unavoidable reason for the length of time, there's no fault, reasonable diligence has been followed by the prosecutor and everything, well then the defense has to show prejudice. The third prong of this test is the defendant's assertion. So while under the length of time, you don't have to assert for the time to run. If you're going to get past the constitutional speedy trial, third prong, you have to have asserted your constitutional speedy trial. You have to have done it. It's how often you've done it and how much force you put into it. Now, as we all know, objections for the statutory speedy trial in Virginia basically just have to say, I object, Judge, and not really go any further. That's all there is, right? So if you do that, you're good to go under the statute. Under under the constitutional speedy trial, you have to, I guess, stand up there, bang on the table, go, this is a travesty of justice, Your Honor. You cannot do this to my client. He must have his trial now. Something along those lines. And I look forward to seeing that in the transcripts. But something along those lines, and actually make a real objection. And then you get to the end. The fourth is whether there's prejudice. Prong is whether there's prejudice to the defendant. Three things are to be considered there. Was there oppressive pretrial incarceration? Is the accused's anxiety, which they state has to be more than normal anxiety of somebody who's facing trial. It has to be a raised level of anxiety. And does it limit the defense? Does it impair the defense? Now, to show prejudice is on the defendant, who must show that something specific went wrong, is wrong. He's missing a witness, he's missing evidence, and he lacks access to, or something came up, lacked access to counsel due to the length before trial. Three cases here. This is kind of, synergy of three cases: Osman, Ali, and Brown. So if you need any constitutional speedy trial, which I don't expect hopefully they won't shut our courts down for a year and a half again anytime soon. But if you need it, there's your test. Right to confront a witness, dead witness. Actually, that's wrong. This wasn't a dead witness. This was a witness that was found incompetent. A child who testified at a preliminary hearing. In this Vista case, the child testified at the preliminary hearing. When it went to circuit court, the child could not testify because she was found to be incompetent. Okay? And the judge said, so it's really right to confront witness unavailable. And the judge's preliminary hearing said, cleared the preliminary hearing to go in. It was a different charge, though, than what the charge was when it went through General District Court. And the Court of Appeal says that's fine as long as they had the same factual basis and the defendant was cross-examined the witness on the facts, right? It doesn't have to be exactly the same charge as long as it comes out of the same series of facts and it's cross-examined. Contradictory evidence that's discovered after the preliminary hearing does not render the testimony from the prelim bad, but you get to introduce it during the actual trial as impeachment. So we'll come back to Vista in some other cases, in some other areas. Right to counsel, U.S. against Baronet. We get these lists every once in a while where this is from the Fourth Circuit. Of these things don't cut it for getting for getting your client's investigation or your client's interrogation shut down. So this is the list they gave of what doesn't work. Maybe I should talk to a lawyer. Maybe I think I need a lawyer. Do you think I need an attorney? I don't want a lawyer then, huh? I think I want a lawyer. Do you think I need a lawyer? And from this specific case, and this is the last one, I can't use my cell phone to call my attorney. The Fourth Circuit said none of that, all of that's too ambiguous or equivocal. So they have to say specifically, I'm not talking to you without my attorney. Go away. Something along those lines. Excluding the entire prosecutor's office. This is due process in the 14th Amendment. This is when a defense attorney is hired into the prosecutor's office. Occasionally happens. We took Dan in at one time. And when it happens, in this case, what happened was the previous prior defense attorney now in the prosecutor's office, had represented Harris on a prior probation violation hearing. And Harris then, after this prosecutor's in the office, gets a new probation violation and new charges, right? And they file and say the whole office has got to be disqualified because he's in there. And, you have to, as a defendant, prove at least that the former defense attorney had advised of some issue involving your case, in the current case, right? And then there's a way it's looked at in prosecution is presumed to share confidences. In other words, we talk to each other. It gets awful quiet in the office, we don't talk to each other. So presumed to talk to each other about cases and everything. And then the prosecutor has to rebut that and show what kind of screen they had in place. So a disqualified attorney has to acknowledge that he knows he's not supposed to talk to anybody about this defendant. And the other lawyers in the office have to know that they're not supposed to talk to that one attorney about the defendant. And the trial court is supposed to consider, was there a formal screening policy? When did that policy go into place? Is the policy comprehensive? And are the affected files marked and segregated? But I gotta say, this Commonwealth Attorney's Office had it figured out. When they hired this person, they had her fill out, this is the list of people that I can't prosecute. And they had it in the computer. When anything popped up, they marked on the file, not to be seen by JV or whatever, so they made sure it was absolutely done right. And I'm actually pretty impressed by it. And of course, they then prosecuted the guy. So, okay, evidence. Prior bad acts. For those of us who were taught common law evidence back in the day, before they changed it, is under the rules now 2:404B is prior bad acts. And per the cases, and there's 3 of them here, Virginia takes an inclusionary view to prior bad acts. You could have fooled me over the years, but we take an inclusionary view. And it is, if it's relevant for anything other than propensity, it can come in. And the list is motive, intent, conduct, establishing relationship, connection to or leading up to the offense, I think was the old res gestae exception. Opportunity, preparation, plan, knowledge, identity, absence of mistake, accident, and common scheme or plan. All those can act to include it, and etc. But if it is unfairly prejudicial, it cannot be included. And the Court of Appeals is very clear that highly prejudicial and unfairly prejudicial are not the same thing. I'm sure all the defense attorneys in this room are shocked to hear that I am very happy when I have highly prejudicial evidence against your client. It's just makes life so much easier. But if it's unfairly if it inflames irrational emotions, leads to illegitimate references, And the issue of this is a matter of degree, right? If it causes a strong emotional response, the jury is not going to act rationally, then it doesn't come in. However, all this can be limited by mitigation instruction from the judge. Get some water. So all that's going to be played out case by case where how it turns out exactly. And while this is not included actually in 2404B, prior bad act, modus operandi, which prior to the rule change at least, was the only thing I've ever seen allowed under Virginia law, really, although there were other things listed, but that was the only one. And in Harvey against Commonwealth, Harvey again, he'd gone and done this, where he'd gone and broken these drunk ladies' houses and done things. He tried to get it excluded, saying this one's not like that one, not like that one, not like that one. And the court says, look, they don't have to be carbon copies of each other. They have to have a singular strong resemblance for them to be introduced. They don't have to be carbon copies. Bist against Commonwealth, this again is the child witness who, when it got to circuit court, was excluded because she wasn't competent. And as we all know, or I think we all know, under the statute, 268.3, a child's hearsay testimony can be brought in these sexual cases if the child testifies, if it's reliable, first of all, hearsay exception, if it's reliable, and reliability is judged on time, content, totality of circumstances. Basically, anything that gets cobbled together, right? Whenever they say totality of circumstances. And obviously, if the child testifies, then the hearsay can come in. That's clear under the statute. If the child is declared unable to testify, in this case, incompetent, there has to be corroborative evidence, right? Evidence that backs it up. It has to be independent evidence. That can be other witnesses, physical evidence, defendant's statement. The evidence, corroborative evidence, does not have to prove the crime itself. It just has to move the proof forward some bit. And of course, the statute does not require competency to apply. Audiovisual. The date on an audiovisual file, Goldman against Commonwealth. Goldman was a thief, stole from his boss, stole a whole bunch of tools from his boss. His boss pulls up the video on the computer, downloads it to give to the Commonwealth, and the video, when they go to testify at trial, he says, yeah, I downloaded it on the 5th of June, right? But nobody, there's no testimony of when the actual date this occurs at, just when the boss downloaded the video. Now there's an auto-generated code on the video that says it was from, the 3rd of May, right? So the auto-generated code says when it is, but the court, and that was okay for the trial court, said, yeah, that's fine. The Court of Appeals says no. Auto-generated date on the video does not establish the date. And while we all know that the date is not an element of the crime, right, and should not determine it, the court in this case decided that it did, and despite the fact that they got him on video stealing the tools, said because you didn't get the date, and because you didn't get the date in the trial, no good, and remanded or overturned. This is an interesting one because I don't know how you would prove the date per se, because how am I going to? I'm that boss. If he downloaded the video and it's like, well, prove it's from that day. Well, how's he going to prove it's from that day? Well, he's going to prove it's from the day because that's what it is in the computer and it's labeled that way in the computer, right? Well, if that's not acceptable, I don't know how he's going to prove it unless, it would seem to indicate that in these larceny cases that no video would be acceptable. And that can't be right. Or at least that's my position. So that could leave some interesting arguments in the future. Authenticating a 911 call. Okay, so court in this Canada case says there's 3 different ways to authenticate a 911 call. In Canada, by the way, this lady broke up with her boyfriend. Boyfriend came by, shot at her car. She called in and said, oh, by the way, he's also a felon. Well, he's got a firearm. So police were kind enough to go get him. So to authenticate a 911 call, first of all, you can have the custodian there, right? Have them come in and say, yes, this came from our stuff and everything. Second of all, without the custodian, you can do it by certificate under statute 8.01-390. You know, you have to have the date on it, the time on it, do the certificate as it says in the statute, and have the incoming phone number that's available. And then finally, the third way is any other direct or circumstantial evidence. So pretty much anything that the court thinks satisfies getting a 911 call in. Other rules of evidence. Okay, 19.2-271.6. Anybody who's heard me talk about this statute knows that I think it's the most poorly written statute that I've read in years. This is the one that allows diminished capacity in, right? It says it just says it comes in and then tries to salvage it a little bit by saying if it could have some influence on intent, right? But in Calico, the defendant here tries to raise it as an affirmative defense, saying this, it's going to go towards intent. This is an affirmative defense against intent, and both the trial court and the Court of Appeals say no, it's not. And actually, although they don't quite go this way, it's kind of the Court of Appeals thumbing its nose at the General Assembly and says this is not affirmative defense. It's not an excuse for the crime. It's not a justification for the crime. It doesn't do any of this stuff. It's just a rule of evidence. And we'll let it in because the General Assembly says we have to let it in, and that's the reason, right? Now, they're not quite as upfront about it as I'm being right here, but that's basically it. It comes in because because the statute is a rule of evidence and says it comes in. No other reason. Violation 3A11, surprise. Again, another thing from Harvey case. And this is, I think, one of those things where you generally see, we all know that if you violate 3A11, Commonwealth violates 3A11, generally you can get a continuance, a delay to, get the evidence or whatever and go over it. Well, we all know there's a game, and I played it when I was doing defense work too. Occasionally, defense attorneys will let something go, and then when they get to trial, they'll go, objection, Your Honor, that was never turned over to me. Because one of the possible ways the court can handle that is to exclude the evidence, right? And try to get something damning excluded. Everybody knows the game a little bit. And Harvey tried that, or it appears that Harvey tried something along those lines. And the trial court turns him down. And he doesn't do anything further. He objects, but he doesn't do anything further. And the Court of Appeals says, look, if you're going to claim surprise on 3A11, you claim surprise. Well, then you have to ask for a recess or continuance. If you don't ask for a recess or a continuance to deal with what's supposed to be surprise evidence, then they kind of infer you're playing these games, and they go, and that waives your appeal. So if you do not ask for a recess or continuance on evidence you were actually surprised by or claimed to be surprised by in trial, then you have waived your appeal on that evidence. And finally, we've got Shahan against Commonwealth. This is Shahan apparently knew he was going to get charged, knew they were investigating him. Apparently, the detectives in this case weren't exactly being subtle, right? And they're looking into it, and they're going through it, and Shahan files a civil case against the investigators prior to his criminal trial. Prior to him actually being charged, he filed a civil case. They're harassing me. They need to be left. I need to be left alone. Tried to sue them for money. So of course they then indict him for whatever he did, and he wants to introduce the civil suit as proof that they're doing this out of prejudice. And the court says, no, that's irrelevant. You're being tried for a criminal charge. The issue is whether you did it or not. We don't care why they took the charge. The issue is whether you did it or not. So this is not admissible. So beating the police to the court doesn't do you a whole lot of good. And let's go through criminal. Well, that's going to be a while. Yeah. Criminal procedure. And here's the pretrial motions by our speedy trial statute. 19.2-243 of the speedy trial statute. Ali and Brown against the Commonwealth. Both of them say the Chief Justice declaring an emergency tolls the statute. Well, shock that our appellate courts would decide that their own Chief Justice, was able to do what he did, but they hold that. And then in Osmond against Commonwealth, COVID was a natural disaster that holds the statute. The statute is different than the constitutional right, which is a little bit different than what you would see in a lot of cases in the past. I don't know if they actually said they were the same thing, but they kind of inferred it because, our statute is prophylactic that protects you before you even get anywhere near the constitutional speedy trial, right? So, and then they go through the normal reasons why, when it is told. It is told when the defense requests a continuance, concurs in a continuance, or does not object to a continuance, which basically boils down to one rule. If you don't object to a continuance, you've told speedy trial, right? You have to object every time. Well, every time you want to sustain your right. Abatement. This came with all the changes in law, and abatement is when a statute is replaced by another, which technically happens every time they change anything to do with the statute. If they change a comma in the statute, theoretically the old law is gone and you've got a new statute, right? New law. Run into most of the time when they change punishment on a statute or something like that, right? So there are two types of abatement: technical, when it changes punishment, and non-technical, when the conduct is no longer a crime. Under the common law, which is not the way it is anymore, but under the common law, if the law was changed and you'd been charged with petty larceny third, right? That's when we had a lot of deal with. You'd been charged with felony petty larceny, right? They changed the statute, and therefore, the moment they changed the statute, your charge went away because this criminal statute didn't exist anymore, right? Or if they changed the punishment on the statute, like when they changed capital murder to aggravated murder, if you've been charged with capital murder before they changed the statute, and your charge went away. Now, the General Assembly could write into every statute saying, but we want the old charges to still stand, but they had to write that specifically in, and obviously that was forgotten about many, many times, because they changed that with a specific law, 1-239, which sets that exactly on its head, and says that the charges still remain the same unless there's an express provision in the bill. So you're charged with petty larceny third, the General Assembly does away with petty larceny third, life sucks for you, you're still charged with petty larceny third, felony after the change. This raises a really interesting thing for like capital murder, right? Capital murder, you're charged with capital murder, we've got one of those right now, and the General Assembly changed it to aggravated murder. It seems like under this statute, it's still capital murder, right? And if there's any kind of argument on it, every reasonable doubt is resolved against retroactivity. Now, the General Assembly can pass, in part of their law, say the old law goes away, right? But they generally don't. And if the defense is arguing the old law should have gone away or did go away, everything is supposed to every doubt is be resolved against that. Now, of course, purely procedural matters, the change immediately applies, but it has to be absolutely purely procedural, which apparently doesn't apply to the actual elements of the crime or punishment. It would have to be something like, on on July 1, all judges have to tiptoe when they walk into the courtroom, right? Purely procedural matter, doesn't change any punishment or any part of the law as elements of crime. So as of July 1, on every single case, whether it existed before or after July 1, a judge will tiptoe into the courtroom, right? That does that. And there's a number of cases here, Artist Green, Montgomery and Street, that cover all this abatement stuff. That clearly came out of all the changes in the law we had from 2021, 2020. Jury trial selection. You know, a couple, 3 years ago, they passed a statute saying that when there's a jury trial and you're doing voir dire, defendants, or you can tell the jury what the range of sentencing is, right? And they put in there, so it didn't look like it was just pure jury nullification. So they put in there, you know, this is so that the jurors can figure out or can be questioned as to whether they can actually impose a sentence, right? Well, okay. The General Assembly then goes and allows defendants to elect partial juries, right? They don't get jury sentencing unless they can elect to have jury sentencing, but they can elect to have a partial jury, arguably unconstitutional under the Virginia Constitution, but I don't have a way to bring that before any appellate courts. I don't know if they'd listen to me anyway. But they can do it. And in Rock, that's what they did. They didn't take a jury sentencing, they just took a jury for guilt or innocence. And the trial court and the Court of Appeals said, well, that's fine. If you just take a jury for guilt or innocence, you don't get to tell them what the possible sentence is. So that's out. Unless you want a jury sentencing, you don't get to tell them what the possible sentence is. Rehabilitating a juror, we all know that, you know, you're not really supposed to be, or judges and that aren't really supposed to rehabilitate jurors. If they say absolutely no, I can't sit and, you know, on this without having a prejudicial opinion from the beginning. You know, the judge is not supposed to try to rehab them. But in this case, again, Harvey, I think this attorney must have raised every objection and objected to everything in the world. But against Harvey, there was a juror who was kind of wishy-washy. I don't know, you know that. So the judge lays out the standard. Here's the standard, and then he goes now and he asks 3 or 4 clarifying questions. At the end of which the juror says, "Well, yeah, I can do it." Okay. The defendant, and I would have too if I was a defense attorney at the time, said, "No, that's rehabilitation." And the Court of Appeals says, "No, it's not. That's just clarifying whether or not they can sit in the jury neutrally." Motion to strike. We have this McBride case. We've had this every few years. The appellate courts tell us this again. But in McBride, motion to strike at close of Commonwealth's case. Judge says, "Sure, fine, I strike the evidence in count 1. And prosecutor stands up and goes, "Wait, whoa, that's not right, Judge. I got case law, I got statutory law, that's not the law." And the judge says, you know, "Okay, we're going to go to lunch, come back, you can show me the case law, maybe I'll change my mind." And he did change his mind. Commonwealth came back with a well-reasoned, I'm sure, perfectly wonderful argument, and the judge goes, "Oh, okay, you're right. They shouldn't have struck it, so we're not going to strike it." Well, the problem is, the moment he says the evidence is struck, that's an acquittal, and you can't reopen on an acquittal because that's called double jeopardy, right? So once they say the word struck, it can't be taken back. It's over. The trial's over. That defendant cannot be convicted of that crime. The judge amending something sua sponte. In Mackey, the judge didn't really amend something sua sponte. What he did was he had a case where the defendant was charged with some sort of sexual crime between 13 and 15, and it turned out, the child, less than 13, turned out it was actually 13 to 15 by the proof, and the judge himself just said, "Okay, one of these is lesser included to the other. I'm going to change it to the other crime." Well, that's not true. They're not lesser included to each other. They each have a different element. And then, after the trial's done, defense files a motion saying, look, no, you can't do that, they're not lesser included, and, trying to get the verdict overturned, and the judge during that says, well, really kind of what I did was I amended the indictment, and the Court of Appeals says, no, you didn't. They can amend the indictment on their own if they choose to, or by motion, before the verdict, if it doesn't change the nature and character of the crime, right? And then they have to rearrange the defendant, and then they have to have them enter a new plea, right? Maybe it continues. That is clearly not what the judge did in this case, so it got overturned. Affirmative defenses in trial, self-defense, deadly self-defense. Well, this is the same thing as regular self-defense, really. Meet against Commonwealth. The defendant must reasonably fear death or serious bodily harm, and it has to be from the defendant's viewpoint. And he must show imminent danger of harm from overt acts or immediate threats. But the status can change just because right now, Mr. Gilbert's holding a gun in my face. 5 minutes from now, when he's put it in his pocket, I am not in immediate danger, right? That we all can see how that can change. What happened in this Meade case is, and in this case, sometimes you read the facts and you just wonder if the Court of Appeals really believes them. But Meade just magically happens to have his car overheat in a parking lot, and he pulls into the parking lot of a place where there's a whole bunch of people who don't like him, right? And one or two of whom have firearms of their own. It develops, they all try to jump him, there's shots fired, everybody runs. Meade is engaged in a gun battle with some other Yahoo in the parking lot. The other Yahoo eventually gives it up and runs into his motel room, right? Locks the door, gets in there, and then Meade fires into the hotel room. And he's charged with firing into an occupied dwelling, right? And the court said, that's not self-defense. He ran, he went away. Self-defense earlier when there's a whole bunch of them jumping you, but once he's gone into that residence, that's not self-defense anymore. Affirmative defenses, mental affirmative defenses. Heat of passion, Washington against Commonwealth. Obviously, you're trying to get malice out of whatever, probably a murder or some sort of thing such as malicious wounding or something. You're trying to get malice out of the way. And they go, okay, you can try to get malice out of the way by proving heat of passion through, provocation, fear or anger, and an impulse of act. Words alone are never sufficient to do away with malice. So, and in this case, apparently somebody used the N-word, and the court says that does not do away with malice. So, and I assume that applies to all pejoratives. Like, for instance, I'm German heritage. If suddenly somebody among you starts calling me a kraut all the time, I don't get to punch you, right? Or at least if I punch you, I won't get away with it because it's a passion. I'll get a full-on assault and battery. Insanity, Commonwealth motion to strike. This is something that I had not seen before, and I've got to admit some ignorance here. I had seen most insanity arguments had been about jury instructions, whether or not the jury was given instructions, right? Assume that's where you make the argument. Apparently, the Commonwealth can make motion to strike on an insanity, right? I did not realize that before. So, at the end of defense's case, right, defense's case in chief, apparently I can stand up and go, Your Honor, they didn't make their prima facie case, therefore they should not get an insanity defense, right? And the judge can strike all that evidence. I've never seen that done that way before. It kind of makes sense, but I've never seen it. And here's what the court has to think about when they decide whether or not to strike the insanity defense. First, they got to resolve any doubt in the defendant's favor. They can't judge the weight or credibility of the evidence. They can't reject inferences favorable to the defense unless they're just so far out there, they're not logical, they don't pass a common sense test, right? So those are what it's basically the same standard that all the defense attorneys have to face when the Commonwealth has finished their motion or their case in chief, right? Now the defense does have the burden, of course, in the insanity defense of production of evidence of insanity and then proof of it to a preponderance level. Affirmative defense, drug dealer safety valve. This is the one, if you remember, this is the safety valve where you've got a drug dealer who's got mandatory minimums because it's his second or third time distributing Schedule 1 or 2 drugs, right? There's a safety valve there that if he cooperates and fits a number of different things, that he can just get a regular sentence, right? Now, apparently, there are a lot of places where this is just a bad guy. The prosecutor is not going to agree to this, right? And the defense is going through doing all the stuff anyway, right? Showing all the stuff and then turning over a paper showing all the stuff to the defense, to the prosecutor and the police, and trying to say, no, we get this. We did what we were supposed to do. Doesn't say the Commonwealth has to agree to it. We did it. And so here's where it is. The burden of production is on y'all, defense attorneys, right? It's a preponderance standard, and the candidate court says a trial court denying this should articulate the basis. It's unusual. Usually trial courts don't have to articulate much of anything. And they say, here are the elements. No priors under the violent crime section, right? You can't have a violent conviction. You can't have done any involved in this crime. Can't be any violence, credible threats, or firearms involved. Can't have been any death or serious injury, bodily injury. You can't be a leader of the group that's selling drugs. You can't be a continuing criminal enterprise, and you have to truthfully provide information to the Commonwealth, all the information having to do with the offense or any common scheme, conduct scheme, or plan involved with the offense, right? This was a case where they arrested this guy. He had been not only the second or third, but obviously he was getting mandatory time, and he also there were a number of firearms in his house. He turns in a bunch of some paper saying, well, the firearms are actually my wife's. They're not mine, honest goodness, they're not mine. And then he turned in a whole bunch of statements about here's how the dealing worked and everything. Obviously didn't work for him. Competency. VISTA against jury instructions. Competency. VISTA against Commonwealth. Again, this is the one where the female child had testified during the prelim, but didn't testify live during the actual trial. The defense attorney wanted an instruction on competency, right? And the judge said no, and the Court of Appeals said, yeah, the judge is right. Competency is entirely a judge's decision. It is nothing that is supposed to go in front of the jury. It could confuse the jury as to credibility, right? Which, of course, if I'm the defense attorney, I'm standing up and going, well, what do you think I want? I want them to measure this. She's incompetent. She doesn't know the difference between right and wrong. That's what incompetent for a child means. That should be impact on the credibility, right? That would be the defense's argument. It didn't carry the day. So if somebody's incompetent and their evidence is entered, you don't get an instruction to the jury about that. On the other hand, accomplice testimony here, Holmes against Commonwealth, he and a bunch of his buddies got drug charges and they all testified against him. Kind of reads more like a federal case than it does a Virginia one. Holmes is, he has a number of witnesses testify against him. He asked for uncorroborated witness or uncorroborated accomplice instruction, and the trial court doesn't give it, and the Court of Appeals says that's wrong. If it's uncorroborated, the defense is entitled to an instruction, a cautionary instruction about accomplice testimony. And corroboration can't be from another accomplice, right? So if we call up 7 people and they all testify and they're all accomplices, that's still uncorroborated, right? Even if they all say the same thing. Corroboration has to relate to facts needed to convict. So, I can prove that his car is blue, but all his drug dealing's been going on in the house. it doesn't do any good. It's not corroboration. And does not need to be, but corroboration does not need to be sufficient to convict or establish all the elements of the crime. It just has to be enough to push it forward slightly to corroborate. Preserving objection to an improper Commonwealth's argument. I'm sure this never happens. You've never seen it, of course. But yeah, if you want to object to an improper Commonwealth's argument, you have to object while the Commonwealth is arguing. You can't wait till later. You have to state your basis for the objection while the Commonwealth's argument is going on. Can't wait till later. And you have to articulate that you want either a cautionary instruction or a mistrial while the Commonwealth is arguing, not later. And in this case, again, this is the Harvey case, the defense objected. The judge just immediately says, overruled, you can state your reasons after the jury is retired, right? Which is what he does. And the Court of Appeals says it doesn't work that way. You have to, if you do not request cautionary instruction or mistrial while the jury is still sitting there and the Commonwealth is making his argument, you have waived your appeal on that. And they do say you as a defense attorney are obligated to point out to the judge that the action needs to happen before the jury retires. Because, once again, the Court of Appeals is proving that it doesn't care if you get found guilty of contempt, right? You just have to shoehorn it in and get there. Sentencing, duration. Pretrial home incarceration does not get credit at all. I know we've had issues with this over the years, and I don't know if we're really using pretrial home incarceration much anymore, but no credit. So your guy spends 2 years at home on home incarceration waiting his trial. He gets 1 year, 6 months, and you go, well, Judge, he's obviously already done this. No, he hasn't. He hadn't done a second of it. So that's where the law stands on that at the moment in that Maryland case. A new sentencing law, we already covered this a little bit with abatement, or we covered it with abatement, but penalty at time of offense applies unless the Commonwealth decides to use the current penalty and the defense agrees, right? So again, interesting implications for capital murder and aggravated murder. And here's another one, this Belcher case. This is something we run into every once in a while. Every couple of years, the Court of Appeals, Supreme Court has to tell us this again. 1 year does not equal 12 months. 12 months does not equal 1 year. Months are not a sentencing, a way you can sentence, except on misdemeanors, class 5, class 6 felonies, and if they're given less than a year, you know, or some indeterminate felonies like grand larceny, right, where you can get a sentence that's less than a year. What happened in Belcher case was Belcher was convicted of a whole passel of misdemeanors. The jury wrote on the findings, you know, sentencing findings, 1 year on each of them. After the jury was gone, the judge just went, well, they clearly meant 12 months. And the Court of Appeals says, no, doesn't work that way. A year is prison time, months is jail time, never the twain shall meet. And if you sub one for another, you sub one for the other, you are outside the statutory range, and you are and the defendant is entitled to a resentencing. So something to keep in mind. I mean, I think we all would like to go to the federal system where they sentence by months, or at least it would make things a lot simpler. But that is not, and our Court of Appeal is very much hung up on the words of it, right? Oh, and let me go further here. In this case, if your client should have got 3 years and instead he gets 36 months, right? By the way they say it in this case, I personally don't read the statute the same, but the way they say it in this case, your sentencing credit your client is supposed to get will not apply because it's a felony and he didn't get years, right? Because they say in here, for the sentencing credits to apply, it has to be a year, or at least a year. And at this time, they're talking about the 12-month, 1-year thing, but it seemed out. I don't agree with them on that particularly because this felony, I think that if you get under a felony, you can still get month sentences, right? In grand larceny, you would get a 6-month sentence, and I would expect that to apply, that statute to apply, but they don't seem to. So be aware of that. And we'll see another opinion like this in another 2 or 3 years. They pop up every so often. Restitution, insurance. Insurance is allowed for both the victim and the insurance company. So please don't come to me in a trial and go, hey, he got the insurance company paid off, so there's no restitution. Yes, there's restitution. Now, I will tell you in all truthfulness, quite often the insurance companies are too lazy to ask for it, right? And I've had to try to track these down. I've tried to track some of them down, can't get them to tell me anything. But if the insurance company asks, or they're available, they get theirs just as well as the victim gets his, but the victim's part of it would, of course, be the copay or whatever. Schlusser against Commonwealth, the payment by an insurance company is a reliable indicator of a loss. However, if the insurance company offers a payment and hasn't paid yet, it's not. The Commonwealth has to show relationship to the loss and the offer, which I would expect to be fairly easy, but they do. And then they go through in Schlusser about all the purposes and everything for restitution. Purpose number 1, make the victim whole. Well, yeah, of course, that's there. Reason number 2, deterrence. I don't know if that really fits, but they say so. Rehabilitation. Yeah, if the defendant really is trying to make himself a better person, he should pay it off. And retribution. There's nothing about restitution that's retribution, at least in my eyes. But this case says so. Court can require a feasible plan considering the defendant's net worth, defendant's earning capacity, and it can permit deferred and installment payments, and it can order payment during confinement. Obviously, they have to be able to pay some hours during confinement for that to apply, but not. And they're clear, what they're talking about here is they're saying that less than the amount that's actually lost, that the victim has lost, can be set by the judge, right? Which strikes me somewhat ridiculous, but they can set it that way. Now, upon non-payment, the court cannot automatically revoke your client's time and send him to jail. They have to bring him in, determine whether or not the non-payment, whether or not they're really at fault for the non-payment, right? If there was any way they could have paid it, or if they just didn't pay. And then they have to consider reasonable alternatives if the person's not really at fault for non-payment or restitution. Post-trial, 21 days. Another thing we see every so often, Rule 1.1 gets explained yet again by the Court of Appeals. 21 days means 21 days means 21 days, right? Once the final order's in, you're on a clock, right? You do not extend that 21 days by filing a motion. Doesn't do anything. Doesn't accomplish anything. The 21 days, the trial court taking something under consideration, your motion under consideration does not extend. So you stood there and made the most wondrous argument ever seen in front of the court. I mean, tears are wept. The Commonwealth attorney is convinced. Everybody there, the judge is just so verklempt that he can't really issue his opinion right at that moment. He says, give me a week, I'll get you something. Well, the 21 days runs between that hearing and the week when he's back to give you the ruling. Life sucks for your client, right? So you have to make sure everything happens within 21 days. And if a motion's pending in any way, shape, or form, that does not toll the 21 days. We all know they're serious about these 21 days. They have been forever. Expungement. Fun stuff with expungement. Fornes he was charged with DUI third, right? Felony DUI. He gets convicted DUI second. The Commonwealth can't prove that it was his third time. They can only prove second. He then wants the fact that he had been charged expunged. He wants that felony off, but he says it's hurting him getting jobs and things. And the Supreme Court says no. The Supreme Court says that's not a dismissal, that's not a null pros quae, that is not an acquittal. You're stuck with it, it's on your record, life goes on. And then further go to say, you were still convicted of the same crime. This is just a punishment issue that's on that statute. Obregon against Commonwealth, okay, you have to look at, when an expungement comes up, court's supposed to look at reasonable possibility of prejudice, doesn't have to be actual prejudice shown. Supposed to be more permissive for misdemeanors. Misdemeanor dismissal is not less likely to prejudice someone than a felony dismissal. And if your client's got a lengthy unexpungible record, he's on different footing. So he's got 17 pages of unexpungible, convictions and things. You go before the court to get rid of that driving suspended that he got acquitted on. Judge might not consider that in the same light. And down here at the end, 19.2-303, suspending it. We all know after your client's been sentenced, that the sentence, you can come back to court and ask for that sentence to be suspended on a felony as long as he's still at the jail, or now, they changed the law a couple of years ago, still at the jail or within 60 days of having been at the jail. So that's all there. You can do that. There's hoops that you should have to jump through for felonies, but you can do that. But you have to prove that he's within the time frame. So he's off at Red Onion, having gotten out of our jail and gone directly to Red Onion. You have to prove it's within 60 days. Okay, violent crimes. Spanking a child. Woodson against Commonwealth. In Woodson against Commonwealth, mom had 2 twins, one male, one female. She found the male one morning. They're younger, elementary school, I guess. It finds him with a text message on his phone, which was against house rules because they weren't supposed to give their phone number away to anybody. She asks who gave the phone number away. Both the boy and the girl say him, her, point the other one. And so mom does what moms universally do. She punishes both of them, right? I mean, at least that's the way it worked in my house. And she had them both lean over the bed, took the soft into a belt, and whooped them both. Spanked them both. 5 to 10 blows, if I recall right. And so at that day, then goes on with the morning, sends them off to school. That day during school, the boy goes to the school resource officer and says, "My mommy spanked me. I'm scared." Right? And they then start the whole kit and caboodle. And they convict her of endangering her child. And Court of Appeals, yet again, this is another one of these things that pops up every few years, says, yes, they can spank their children. We realize you don't like it. This is not something you would do in your enlightened way of raising children, but parents are allowed to spank their children. And even if it leaves, transient minor marks, that's not enough for conviction. So they go through it and say parents can use corporal punishment within moderation and reason. It's immoderate if it threatens to cause serious harm or actually causes it. Bunch of factors: age, size, child's conduct, nature of the misconduct, instrument used, kind of marks left, and the emotional state of the parents. Transient pain or minor temporary marks is not enough to convict the parent of anything. Disagreement with the parent's use of corporal punishment is not enough to convict the parent of anything. Spanking with a soft end of the belt, and they don't specifically say this, spanking with a soft end of the belt is not so unusual, cruel, or degrading that it qualifies. Which is good because, well, it's too late to charge my parents, but there would have been a lot of charges at my house. In order to prove that it's beyond that, beyond just a regular corporal punishment situation, you have to show significant injury or evidence at least of a number of blows. If they hit them 57 times across the legs, or a dangerous location if they're starting to belt them across the face or something, right? So it doesn't apply, spanking is not illegal. A child's generalized expression of fear about returning home from school doesn't support particularized conviction. So the child complaining to school officials or the SRO doesn't cut it. I can tell you, there were times I was scared to go home when I got bad grades, right? I was, that didn't mean my mom, was going to be too abusive about it, but so spanking is legal. This is a wonderful case for those of you who are working in domestic court. Say again? You can try. I don't think they'll listen. The sex crimes, consent. Conley is married, has an ex-wife, right? They were married for a period of time. They're both druggies and alcoholics, and they are doing whatever they do, and they get divorced. Then they move back in together for a while. She kicks Conley out, and after she kicks Conley out, she finds his phone, right? You wonder whether they actually believe this, or he'll believe these things sometimes. She finds his phone, goes on his phone, and finds videos that he has taken of himself doing things to her while she's zonked out in drugs and alcohol and unaware. And then she accidentally signs into his iTunes or his iCloud, and while trying to sign out, sees more videos of herself unconscious with him doing stuff to her. I don't know why they even bother with like the charade, because it doesn't matter. He did it, and she's a private citizen, so we don't have to excuse it. But what they do say though, he's like, we were married and we had sex all the time. She consented to sex, and the court says no, it doesn't work that way. Consent has to be ongoing, right? And at all times, the other person has to have the ability to withdraw consent. So fill in the blanks. I'm sure there are all sorts of nasty jokes to be made here, but whoever you're having dalliances with must be able to withdraw consent at all times. Otherwise, it goes into sexual crime zone. An unconscious person obviously cannot give or withdraw consent, even if they consented to it beforehand, afterhand, any other time. Drug crime, pure methamphetamine. Okay, if it's between 10 and 20 grams of methamphetamine, if it's above 10 grams, there's extra punishment, right? But between 10 and 20 grams, the methamphetamine has to be pure, right? This also would apply that the other enhanced punishment above 100 grams would have to be, between 100 and 200 grams would have to be pure. Now, above 20 grams or above 200 grams, it doesn't matter how much it's mixed with. Your client's just toast. But between those zones, it has to be pure. Commonwealth, the Court of Appeals, of course, is not kind enough to tell us what pure means exactly. Right? There is no such thing as anything that's absolutely pure, probably this side of heaven. And so, does it mean 95%, 98%? What? The Court of Appeals doesn't give us that information. Okay. Holmes against Commonwealth. The fact that it is such and such drug doesn't have to be proven by a certificate of analysis. It can be proven in other manners. Circumstantial evidence, the physical appearance of the drug, if it produced the expected results, if it was used in the expected manner, if it was paid for by a high price, if there were secret, devious transactions involved in it. And if the defendant said it was meth, it's meth, right? At least that's a strong circumstantial evidence. Furthermore, a user or addict who has experience with the drug can testify and help identify the drug in court. So, Theft crimes, computer fraud, ATMs, Wallace against Commonwealth. Wallace, who had an account at the bank, put in several fraudulent checks through the ATM, right? They were forged, they were uttered, all this other stuff. And then she did what they all do, went and spent the money before it could be, before the bank figured it out, right? And she got charged, among other crimes, with computer fraud for having used the ATM. The Court of Appeals said, no, you've got to prove that she was exceeding her ability to use that computer, not what her purpose was, that she was exceeding what she was allowed to do. So basically, you would have to, and that she exceeded authorization. So basically, in order to convict in that circumstance, the prosecution would have to provide, I guess, whatever contract she had with the bank as to use of their equipment. Now, I will say, this just got accepted like last week for en banc, so next year there'll be an entirely new opinion about that, but that's where it stands. Grand larceny, we already went over Goldman. If video is the only evidence, the date of the video must be proven. Again, I don't know how you're supposed to do that. The boss downloaded it. On his computer, it says it's the 3rd of May. The file says it's the 3rd of May. He hands it in, and if he says to the judge, says during testimony, well, yeah, it's from the 3rd of May. And on cross, it's like, well, where did you get the information it's from the 3rd of May? Well, it was on the computer and labeled and that. How is that different than just using what automatically is generated on the file? But that's where it stands. They could be trying to get around with, we can all screw with files. They could be trying to get around somebody screwing with the title, the name on the file. That's about the only thing. Weapons crimes, concealed weapon while intoxicated. The statute says it must be on the person, not on or about. So unlike other possessions where you can have constructive possession in the car, in the bag, this time I think it was in a bag in the car, right? In both of them. That's about, that's not on. And therefore, they found Morgan is not guilty of this. It has to be actually on their person. Motor vehicle crimes, Alley against Commonwealth. This is the hit and run statute. If for injuries, knowledge is imputed if you see the injury or you realize it's a serious collision, and you have duty to render reasonable assistance if the need is apparent or if it's requested. So what's going on in Alley is he picks up his girlfriend, he's riding down some country road at maximum speed he can get his car to go, right? To the point that the police find the scene once, and they chase him, and they lose him, right? He pulls over at a certain point, his girlfriend yells at him, says, let's go where we're supposed to go, don't ever do that again, at which point, of course, he gets the car going the other direction, and gets it right up at the same speed, going ridiculous speed, again on this country road. Again, the police officers start chasing him, and again he loses them. Doesn't do him much good this time, because eventually he goes down the road, and he goes off the road. Car tumbles. Both him and the girlfriend get out. They run to the woods that are nearby. Girlfriend's like, I need to go to the hospital. I'm hurt. And he's like, well, I'm not going. And she won't go to the hospital because he's not going, right? And that goes on, there's a soap opera attached to all this, but that goes on for like the rest of the night, and I think the next day the officers figure it out. When she actually does go to the hospital, family members or somebody take her to the hospital. So, hit and run, he left the scene of the crime, right? And he had somebody who was injured, who was asking for assistance, his girlfriend, and he didn't render it, didn't take her to the hospital, therefore he's guilty. So, I hadn't seen that statute stretched so far when it passed. And under DUI, second or third, Yemelyanov against Commonwealth. Okay, so Yemelyanov gets convicted of his second DUI, and he, final order is entered, he appeals it to the Court of Appeals. In the meantime, he gets the trial judge to suspend execution of the sentence. And then, while he's waiting in the Court of Appeals on his DUI second, he gets another DUI. gets charged with a third. His argument is, look, that case wasn't finished. It's still ongoing. The judge has suspended execution of the sentence, and the Court of Appeals says, we don't care if he suspended execution of the sentence. There's still a final order. You were still guilty at a second, and once you're convicted in trial court, even if you appeal, it's treated as conviction. So he got his DUI third. Probation. Probation equals suspension. So, as we all recall, a couple of years ago, we started talking about Green and how the statute had suspended, period of suspension, and had probation. The two are different things, and how if it didn't have any period, any time suspended anymore, the probation went past it, it was meaningless, right? That was basically what we all kind of came out of Green. And the Supreme Court said, no, it doesn't work that way. If the judge just extends the probation, he automatically has extended the suspension of time. That's not in the statute anywhere. I know that the appellate courts say they never write anything into the statute. They're not supposed to. They wrote that into the statute, right? I mean, it's a mess. It's an area of law that really needs to be fixed. The statute needs to be fixed. That's not in there, but they're the Supreme Court, so they get to say it is. Technical violations of probation, Hart against Commonwealth. All priors must be technical violations themselves. So, your guy gets a first probation violation for robbing a bank, second probation violation for kicking his dog, and the next probation violation is for absconding. Or let's not say absconding, for turning up hot. He's hot for meth. That's his first technical violation. Despite the fact he's had serious probation violations previously, that's his first. And he has to have another technical violation to get second, and another to get the third. So, you're only counting technicals. Henthorne against Commonwealth. Any failure to sign up for probation within 72 hours is technical. This, of course, is contrary to the law, which specifically says any failure to sign up within 72 hours of release from incarceration is a technical. But the Court of Appeals says, no, it's all of them from 72 hours. So that's the law now. They kind of wrote something out of the statute. And in Delane, if in the statute it's technical, we don't care if the judge put it in his final order as a condition, right? Delane was convicted prior to the change. It was written in the final order by the judge. It comes to court, and the judge is like, yeah, I know it says it's technical in there, but it was in my final order. I had ordered him to do this. He violated my order. That's what we're here for. And the Court of Appeals says, no. If it's a technical violation, it's a technical violation. You can't get around it. And we get to appeals. If you have no opportunity to object, we all know that you under 5A 525:25, you have to object timely, right? If you have no opportunity to object, then you don't have to object at all, right? So what happened here was, during all the COVID shutdown, after longer than 10 days had passed, and Jax appealed something from the General District Court to the Circuit Court. Circuit Court judge looked down and said, that's 15 days, just dismissed it without having any hearing or anything, right? And Jax appeals, and the Court of Appeals says, well, no, that was done outside of Jax's presence. The attorney wasn't there, the client wasn't there, nobody was there, and even if there's further argument on different things later, the attorney doesn't have to raise it because the judge did it outside of his presence. That would be, see under Connolly against Commonwealth, good cause exception to the contemporaneous objection rule requirement. Good cause exception only applies when there's no opportunity to object to the ruling in trial court. So that's where that stands. Preserving an argument. For years and years and years, the courts have told us you argue at motion to strike that the Commonwealth's evidence is wrong, that this is terrible, that his argument is unconstitutional, illegal, whatever, right? If you raise the same issue in your case in chief, you waive that, right? It's gone. That's been where it is forever. Well, now they say, you know, well, you don't really waive it if you raise it in cross-examination. And you don't really waive it if you're raising it in rebuttal of the Commonwealth, which is interesting because your case in chief is also your rebuttal to the Commonwealth, right? So where that line is going to be drawn, you know, I leave in your good hands to argue for the courts, right? Because there's not really anything there. So it gives you a lot more room, at least to argue that you can still have your appeal. That's it for it. As always, look at the cases yourself because I am far from perfect. This is generally kind of giving you an idea of where to look. Look at the cases and figure it out, and I hope it's helpful. Everybody have a good day.